Thank you. I think as we go along, you'll see more and more and hopefully be able to kind of develop your own sense of what we can and should be doing here in California. So I thank you, folks, very, very much for your time and your interest. And I hope that if you have further insights and all, that you'll please share them with us, because this is a very important issue. And I know this year there will be a number of pieces of legislation. We want to get it right. So thank you very much for your time and your interest.
Thank you.
Very much.
You bet. All right, would our next group of folks come up? This is the section on mandatory arbitration clauses and their impact on California consumers and employees, which I think will be helpful to you, Senator Morlock, in that question. We have Catherine Stebner, who is the founding partner of Stebner and Associates, Alan Carlson, who is the owner of Italian Colors Restaurant, Cliff Palevsky, a partner in McGuinn, is it, or McGinn? McGuinn, Hilsman and Palevsky, Stephen Lively, a major with the United States Army, Paul Kane Jr., a partner in Paul Hastings, and Donald Falk, a partner with Mayor Brown. These are some very heavy hitters, so we're going to listen very carefully to what all of you have to say, and we'll start with Catherine Stebner. So nice to see you.
Nice to see you. Son, hello. Thank you very much for letting me come talk to you about what's happening in nursing home and assisted living area. My name's Catherine Stebner. I'm the principal of Stebner and Associates in San Francisco. My firm represents consumers in both individual and class actions involving skilled nursing facilities, which are nursing homes, and residential care facilities for the elderly, which are assisted living facilities. I've been representing families and elders since 1987. I know that I look like I'm 35, but a child prodigy. I am on the LRS board for California Advocates for Nursing Home Reform. I am the executive committee for Consumer Attorneys of California, and I am the past president of the San Francisco Trial Lawyers Association. So since 1987, I've seen an explosion of arbitration agreements and contracts for admissions in both nursing home and assisted living facilities. And all contracts in these cases have arbitration clauses. I'll say it again, every single contract when you go into an assisted living facility or a nursing home in California has an arbitration clause. I will also tell you that in every single one of these contracts, they are all one-sided, and I'll go into that. Every single one is one-sided. I will also tell you in every civil contract, it is in the middle, maybe a third, maybe 3/4, but in the middle of a 30 to 60 page contract in every single one of them. In California, California Health and Safety Code section 1599.81 states that all nursing home contracts that have arbitration clauses must state that the agreement to arbitrate is not a precondition to admission. Again, this is, on page 45 of 60. In the assisted living arena, there is no law. There's no law. And I think that Senator Jackson used the word duress factor. And in this area, there is a duress factor that is giant. In reality, what happens is an elder arrives at a nursing home on a gurney, on morphine, on the way from a hospital in an ambulance, and they're sent into a room, the family member goes in there, and a contract is to be signed. If the resident is a Medi-Cal resident, there's hardly any beds in the state of California. It's very difficult in California to find a Medi-Cal bed. Some facilities don't even take Medi-Cal, and most hardly take any. In rural areas, many rural areas in California only have one nursing home, if you're even lucky enough to find one with a Medi-Cal bed. So you may have to send your mom, who you want to go see every day, 150, 200 miles from your home. And then it's a take it or leave it also when your father, who's demented, who cannot take care of himself, you've got to take him to the only assisted living facility in your town. And you get there and there is no law and you have to sign the agreement. So I would say that is a take it or leave it. situation under duress. It's a perfect example. The language in arbitration clauses in nursing home and assisted living include, every single one of them is one-sided. It says, if you want to sue us, you've got to go to arbitration. If we want to sue you, we can go to court. Every single one of them says that. Arbitration of fees must be split. So, and as was told before, it's very expensive. Many arbitrators, as you know, are about $1,000 an hour. Those are to be split by both sides. There are class action waivers, which I will talk about a little bit more in the end. Again, as Senator Wachowski stated, the laws are, you have different laws chosen by different states. You got to go to a different town. They choose the arbitration company that it's going to be, and which will be on the third panel. And again, there's no right to appeal. And this is in every single one. And we have passed out some of those to this committee. A big problem that hasn't really been addressed is a problem with our living clients. So I've said this many times, my clients are either demented or dead. So I represent, if my clients are living, they're demented, so the family member has signed the arbitration agreement, or they've passed away because of something that happened. So in my cases, where probably about 25% of my clients are still living and demented, there's a law in California, it's called a right to preference, and it's a great thing, and it says if you are 95, 92 years old and you want to have a right to a trial, you can have a trial with 120 days. Okay, so we have that. I have a client who was in her 90s, who was raped in a nursing home and contracted herpes in Monterey County. The facility filed a motion to compel the arbitration that her daughter had signed, and we won. They lost. And we also had a motion to have it heard within 120 days. We won that too. But the nursing home chain filed an appeal. And so what they do in every single one of these cases is they file appeal and they wait for my client to die. And that is the law. It's one-sided. So if I lose that, I can't appeal. But if they lose, they can appeal. So here you have two very strong sets of laws in California. One that says if you're older, you should be able to get to the courthouse, butting its head right up against the other that says, no, you have the right to appeal it, and it takes a year to do that. And it's done, and I've been told by the defense bar that they are, they're waiting for them to die. So they don't get their day in court. My client, who was 92, said, I'm going to outlive this, and she did. And the case resolved after we won, after we sat with the appeal. This is a Hobson's choice for the elderly. If they're living, they have to either agree to the arbitration or they might die. That's this decision. And I wrote this, and I wrote the words Hobson's choice, and I actually thought Hobson's choice meant something different than it means. I thought Hobson's choice means you had two really bad choices. Actually, Hobson's choice, Thomas Hobson from Cambridge, had a stable of 40 horses. And he said, you can ride any of these horses that you want. But what he did was he always made people choose the one horse that was right when you walked in. And so Hobson's choice actually means take it or leave it. And so that's what's happening in California. It's take it or leave it. The one horse that's sitting there is the one nursing home in your town. So my suggestion would be a legislative fix to address forced arbitrations in these cases and give the elderly the speedy justice that they deserve, that this legislature has actually said is important. We need to end forced litigation arbitration for both individual and class. So for me, my firm does a lot of class actions, and we focus on staffing issues, not having enough staff in facilities in California. And the reason that we do it is because we're interested in injunctions. Because there's a class action waiver, we cannot bring injunctions to basically force people to follow the law. Acting as private attorney generals, because the state of California is underfunded in doing this, so a group of us have been doing it. But without the class action and with the class action waiver, a facility-wide injunction is not possible, and this is certainly not something that is bargained for. So we have a broken system, a system that allows the abuser and rewards the abuser, harms the innocent victims, and I believe we should judge ourselves by the way we treat our elders. Thank you for this opportunity.
Well, you went under 10 minutes, so it allows me to ask begs the question. Mr. Olson indicated that you can't treat arbitration agreements differently than you treat contracts. I wonder in this case if by giving seniors, giving our elders that priority, we are treating them differently. Do you agree with his analysis? And if not, or irrespective of whether you agree, is this something where you think there is some precedent, there is some way that California could do that, particularly in addressing our elders, so that we can give them some of these protections?
Yes, at least in respect to the right to the speedy trial, which I think you're talking about. You know, we have been working on some language that we'd like to discuss with some of you in order to try to fix that situation, because it is a contradiction in the two laws. And we do think that we can do that, yes.
Thank you very much. Our next witness, Alan Carlson, who has a very interesting story, the owner of Italian Colors Restaurant, which rumor has it was great or is a great restaurant, so I'll give you a little plug there, and very interested in your story, and thank you very much for being here.
Good afternoon, Senator Jackson and committee members. Thank you for having me. Like you just said, my name is Alan Carlson. I'm the owner and chef of Italian Colors Restaurant, a small business located in Oakland, California. I have owned and operated Italian Colors with my wife, Diane Cohen Carlson, and business partner, Stephen Montgomery, for more than 24 years. Like most restaurants, our profit margins are thin, but we can rely on a local clientele who visit us for our friendly atmosphere, reasonable prices, quality food, and great service. A significant percentage of our earnings come from our customers who use American Express cards. Most of these customers are not aware that American Express imposes exorbitant fees on small merchants who accept their cards, much higher than other forms of payment like Visa, MasterCard, and debit cards. Until very recently, American Express prohibited us from letting our customers know about the company's charges or steering them towards cheaper forms of payment. This prohibition isn't just anti-small business, it violates federal antitrust laws. I tried to stand up to the credit card giant on behalf of myself and other small business owners and sued American Express in a class action, which is the only practical way a small business can assert its rights under the antitrust law. I soon discovered that without my knowledge, American Express had taken advantage of a legal mechanism that allowed it to avoid having to defend itself in a class action. After many years of taking American Express cards, they changed their terms and conditions to include a forced arbitration clause in the fine print of its contract with me and other merchants. This means that anyone who does business with them gives up his rights to go to court or bring a class action. Instead, disputes must be settled through an individual private arbitration process that was designed by American Express. I fought American Express and its forced arbitration clause all the way to the U.S. Supreme Court, and I was hopeful that the justice would finally open the courthouse's doors to us. Instead, the court ruled in a 5-4 in favor of American Express. The decision issued in 2013 strengthened corporate America's ability to use forced arbitration against small business. The court determined that even though a class or group action may be the only way for a small business to pursue important rights against a big business, it's simply too darn bad, choosing forced arbitration over the pursuit of important federal rights. Because of forced arbitration, I was prevented from joining with other small business owners to help defray the cost of enforcing our rights. The cost of individual arbitration would be so high that even if the small business won, it would lose. An expert economist explained that it would not be cost-effective for any small business owner in the same situation to pursue an individual arbitration claim against American Express. In fact, it would cost more to bring their claim than we could ever recover. When credit card companies and banks added secret fees or use other unfair practices to deprive their customers of millions of dollars, class action lawsuits are how we get our money back and help keep big business honest. Our ability to band together, especially when individual claims may be very small, helps deter the banks from doing it again. Government regulators neither have the resources nor the same priorities as consumers and small businesses who need the ability to file class actions to protect themselves. In short, if I and other small business owners cannot be part of a class action to enforce our rights against American Express, and if we are forced into a private and expensive forced arbitration proceedings, we are being deprived of these rights, which may exist in our law, will have no practical meaning for me and others like me. Thank you.
Very much. And I think part of what we need to acknowledge at this point is that these contracts that are take it or leave it, which many of them are, do also include as one of the requirements that you waive any right to a class action suit, which effectively, as you mentioned, I think for many small businesses and consumers makes it impossible to proceed. This is an issue in and of itself, but as I understand it, and so I want to acknowledge that, so as we go forward, it is really one of the key impediments that is one of the benefits of these mandatory arbitration requirements that simply takes away a very significant tool that would allow for sort of better equalizing of the playing field. That might be the subject of a whole other hearing. So I'd ask that certainly it's important, and part of the reason that we wanted to have you testify is that this really is a problem, not just with employees and businesses and consumers, but also small businesses versus larger businesses, and you were an example of how that happened, that you were refused the opportunity to come together as a class with many other small businesses having the same experience. And it is definitely part of the whole issue. But again, if the Supreme Court allows these to take place, then this is something that we have to also consider as we try to deal with the preemption issue. But I wanted to recognize the significance of the waiver of class action suits that we find in almost all these these mandatory binding arbitration agreements, at the same time wanting to focus, if possible, on some of the other options, because that may be a whole subject matter in and of itself. I hope I'm being clear. Sometimes this is a difficult area, and I'm as clear as mud. But I hope that the rest of you are a little clearer. It is a very frustrating area when we look to justice, as I had mentioned in my opening remarks, to be fair to all of us. And that as you hear these kinds of stories, the game seems to feel a little bit rigged sometimes, and I'm wondering, as we go forward, if you might have some suggestions, or if you think the system is perfectly fine the way it is. This is a discussion that I think we want to hear, and your perspective as experts in the field and people who have either experienced it or who have litigated these issues. So I wanted to thank you and acknowledge the importance of that topic as well. We have now Mr. Palevsky, if you would like to proceed.
Thank you very much. I can help you with the class action prohibition as I get to it. Let me just introduce myself and my biases. I'm an employment and civil rights lawyer. I've argued 7 of the leading cases to the California Supreme Court on arbitration, including Armendariz and Gentry, and the Sana Calabasas case twice, which has the effect of precluding access to the California Labor Commission. But something that you might not understand, I love and support ADR. In fact,
ADR being a
alternative dispute resolution concept. In fact, in the early days, both JAMS and AAA asked me to help draft their protocols, their rules of fairness, and they tried to get me into their marketing press releases because I am such a big supporter of ADR. Everyone who truly loves the institution of arbitration opposes mandatory arbitration. When you make it mandatory, you are perverting the very essence of arbitration. The only check and balance that was ever contemplated so that you could keep the courts out was the consent of the parties. When you eliminate consent, you're turning an adversary system over to one side of a dispute and inviting them to write the rules. It's an invitation that few companies can afford and do turn down. Let me tell you that in the employment field, you have a lot more flexibility in what you might be able to do for a few reasons. One is the FAA does not cover all employment relationships. Transportation workers, tens of thousands of workers in the airline industry, the railroad industry, seamen, truckers. So there's a lot of California workers where there is no preemption. Importantly, There are federal statutes. Preemption is the notion of preempting a state law. There is no preemption of one federal law by another. And what's going on right now that you really need to understand is that the National Labor Relations Act has been charged by Congress with enforcing, the National Labor Relations Board with enforcing the National Labor Relations Act. Both the Norris-LaGuardia Act and the National Labor Relations Act say it is the public policy of the United States that individual workers have the right to act in concert, to act together. And for 60 years, that has meant the right to join together and bring class action litigation. And despite what the Supreme Court has said in the context of consumer class actions, the National Labor Relations Board has said repeatedly, and now there's about 40 opinions of the National Labor Relations Board saying that a prohibition on joinder or class actions in the employment context violates the act. It's working its way through the courts. That issue is going to be resolved by the U.S. Supreme Court. And until it is resolved by the Supreme Court, I really urge you to respect and support what the NLRB is doing. Additionally, there are several federal statutes, the Fair Labor Standards Act, which is our national wage and hour statute, the Age Discrimination in Employment Act, the Equal Pay Act, and even California's FEHA, all have written into the statute that you have the right to bring the case on your own behalf and on behalf of others similarly situated. So the right to proceed on behalf of others is written into the statute for a very good reason. It is absolutely impossible for an employee who is still working, who is being cheated out of wages or being discriminated against, to think that you can keep your job while you sue your employer. The very essence of our national labor law is the right to choose representatives, to have people negotiate for you. The class action prohibition, which you refer to, is devastating. It runs counter to these statutes. It runs counter to our labor laws. And what the companies are doing, when I went to the National Labor Relations Board, because I've been involved in these decisions, I explained that this is what it's all about. They're saying you have to bring in individual arbitration. So if you want to either opt out or if you want to sue, you have to put a target on your chest, as opposed to the mechanism which Congress has set up to allow a class action or a collective action where you can either sit back and collect or simply say, I want to opt into your class action. This is an absolute frontal assault on everything that we've ever viewed as fundamental in the labor and civil rights context. Now, despite all of the talk about preemption, most of it is a history lesson. The preemption decisions are mostly 5-4. Justice Thomas says the FAA doesn't apply in state court. So in state cases, it's only 4-4. Now that Justice Scalia has moved on to a higher court, it's not exactly clear what is going to happen, because there has been a national debate, and one thing is clear. No system of justice can succeed without the confidence of its users. There's a lot more involved in a justice system than moving money around. And mandatory arbitration has lost the support and the credibility that it needs. To be clear, not only has President Obama prohibited mandatory arbitration of Title VII claims for any federal contractor, the Department of Labor opposes mandatory arbitration. The EEOC opposes it and says it interferes with their ability to do their job. Congress has, despite what some folks say is a public policy favoring arbitration, which obviously can't be the case if you believe in original intent, because the original intent says the right to trial by jury shall be preserved.
Be careful of trying to find consistency now.
Yeah, that's been our frustration. But Congress has prohibited mandatory arbitration in auto dealer versus auto franchisees contracts, in payday loans for military. There's probably 8 different Sarbanes-Oxley whistleblower statutes. So in the past 10 years, Congress has prohibited mandatory arbitration in a host of situations, and there really is a recognition that it is an abuse of the process and undermines all that is good with voluntary arbitration. I want to just respond quickly to a few things, but before I do, I want to make a point. The California Labor Commission is the most important administrative body out there for people with low wage earners and for people who work for a living and people who need their money for their food and their shelter. It is free. They provide a translator. You have to post a bond if you lose the employer. It is where you go if you can't afford a lawyer. The present state of the law, if you permit mandatory arbitration agreements in the employment context, literally shut the door of the California Labor Commission. So what's happening is this legislature passes the best discrimination statutes in the country. You pass the best labor law in the country, and the employers who you are trying to regulate say, if you want to work here, you must waive those rights. That cannot be. And if it is the present state of the law, you must resist it and do everything you can to find a way around it. So that you know, there's things that you...
I don't mean to interrupt. That's exactly, you've just made the point. I'd like to hear how, if we do not agree with that position, we can work around it.
I'll tell you, there's very simple ways. First, the United States Supreme Court has said certain things, but they have not said other things they need to. What they have said repeatedly is that arbitration under the Federal Arbitration Act is a matter of consent and not coercion. They say it, they say it, they say it, they say it. They've never defined what that means. You have the ability to ensure that in the creation of these contracts, it is truly consensual and not coercive. Second, the Federal Arbitration Act only comes into play if there's an arbitration agreement that has to be enforced. I believe you have the ability to prevent the creation of arbitration agreements in certain contexts unless they are knowing and voluntary. Okay? So last year, for instance, the legislature passed the bill AB 465, which said you may not require as a mandatory condition of employment an arbitration agreement to waive access to the Labor Commission. It allowed arbitration agreements if they were knowing and voluntary. But the most important provision, which you can do in the employment context and in the consumer context, is to say you may not refuse to employ, you may not discriminate against, you may not refuse to provide a service for someone who says, no, I do not consent. The Supreme Court says it has to be a matter of consent and coercion. You have the ability to say, if someone says, I don't consent, you can't refuse to provide that service or retaliate. I don't believe that there is a preemption problem with that. And obviously, no one's going to know what that's going to turn into. The court's doctrine, the notion that arbitration does not impact substantive rights, is simply wrong as a matter of fact. This is not a legal argument. You lose the right to have the law enforced. The law is an arbitration award has to be confirmed even if there are errors of fact or law on the face of the award that result in a substantial injustice. If you lose the right to have the law enforced, you have lost the ultimate substantive right. If you lose the right to act together and get class-wide relief in a statute that says you have the right to bring a class action, you have been deprived of substantive rights. If you can't take depositions that you need to prove your case, you have lost substantive rights.
Great argument. The problem is, hasn't the Supreme Court determined that they reject that argument? I mean, that's what we're here trying to figure out, how in California we can do what's right and what's fair and what's just under the circumstances, the limitations of federal preemption. Are you suggesting, I mean, is this an argument if we were the 9 justices or the 8 justices of the Supreme Court you would make, or is this something that you believe we can still do irrespective of the whole federal preemption issue?
Not only can you make it, the Supreme Court has never determined the level of voluntariness necessary for a valid arbitration agreement. In all of their cases, they start off presuming it's a valid agreement. The only thing they've ever said about adhesion contracts is that the mere fact that it's in an adhesion contract in and of itself isn't enough to make it invalid. And that was in the securities industry context. The employment context is recognized by federal statute to be inherently coercive. So I believe that the Federal Arbitration Act itself, if it applies to the states, is only constitutional if the underlying agreement is knowing and voluntary. Because unlike the commercial context, there's been a lot of discussion about you have to treat an arbitration clause like any other clause. I don't think that's right for a couple of reasons. One is there are routine commercial terms. The other thing is, in an arbitration agreement, you're waiving constitutional rights. The First Amendment right of petition, the Fifth Amendment right of due process, the Seventh Amendment right to trial by jury. In every single context, the waiver of constitutional rights has to be knowing and voluntary. The Supreme Court has never yet, to this day, addressed the concept of the required voluntariness for waiver of constitutional rights.
So quick question, is there something heading to the Supreme Court now that deals with that issue?
I don't think there's any pending cases right now involving this issue at the Supreme Court. And I'll tell you, with a 4-4 split and Justice Thomas saying the FAA doesn't apply in state court, I think a lot of the decisions are going to come out very differently. So don't read the old tea leaves. That teacup's been shaken up, and the world is going to change. But just to respond,
Quickly, because you're a little over your time, and we do have.
the notion that arbitration, that employers have to pay the full cost only applies in a very limited context of employer promulgated plans. If you're hired with an offer letter, if you don't go to AAA or JAMS, it could cost you $40,000 or $50,000 to arbitrate a case. The notion that there are no summary judgments or demurs in arbitration, simply not true. The rules invite. In fact, I got a call from a case manager from AAA who said to me, whenever I see someone going in without a lawyer, they're getting run over. It is troubling me. You have to do something about it.